Good afternoon. Dennis Kennelly here. You're on the legal line. 12:20 a.m. KHTS, our second show. And today we're going to deal with when you need to talk to one of me or one of us, an employment lawyer. And it's probably earlier than you think. The going to a lawyer is a lot like going to a doctor or a dentist. Preventative medicine or preventive law is a lot more effective than finding out after the fact. With me today is my guest producer, Nikki London. You may wonder about the bumper music that you heard leading into the show. That's from a group called London Rain, and that was Nikki London you heard singing. So Nikki's going to be my producer today. Our regular producer, Laura Espinoza London, her fiancé, is, not unfortunately, is enjoying herself standing on line at the Honda Center to see 21 Pilots with her daughter. So Laura's listening, I'm sure, and you can listen by going to the website of the radio station, and you can also find us on Facebook. So there are many ways in order to catch the show.
You can watch live right now at facebook.com/KHTSAM.
Thank you, Nikki. Nikki's also, she had an interesting thing happen to her a while ago, and we'll go into it. It's another example of why it's good to know what your legal rights are, and had she had a lawyer, I think things would have worked out differently. But getting back to when you need an employment lawyer, the most common scenario that I encounter with new clients is the phone call from somebody that says, I just got some bad news at work. I'm being laid off. I'm being fired. They've given me this agreement, which looks like I'm waiving every right in the world that I have. I don't understand it. It's in legalese. It mentions a page and a half of statutes that I'm waiving my rights to. What do I do about this? And it actually says I should talk to a lawyer. So I'm now talking to a lawyer. Unfortunately, for most people, they have a hint that something's going on before it happens. And, you've got to, sticking your head in the sand in these situations is not good. 30 years ago, layoffs and job eliminations and things of that nature were a lot more rare than they are now. The employers feel free under the employment at will doctrine to eliminate positions or, basically eliminate people a lot more than they used to. As, we'll go into a little later, everybody here is an employee at will in all likelihood unless you belong to a union. So what do I tell these people when they come in? What are the kinds of questions that they ask? What they're normally asked to do by the company is they have a sum of money waved in front of them as a kind of a carrot, saying, we'll pay you this if you sign away your rights. Well, what I want to do is find out what rights they're signing away. And these are the kind of questions that I ask them. Hopefully, you've never been through this, but as I said, 30 years ago, it would have been that you hadn't been. But now, everybody I know, even superstars, have been fired at least once. So it's not pleasant, but it's a rite of passage. Okay, the first thing we go into is, touching on what we touched on last week when we talked about independent contractors with my guest, Mark Sullivan. And that is, were they an employee or an independent contractor? Well, if they're offering you severance, they likely consider you an employee, which is a good thing because there are certain things you're entitled to. So before we sign away any rights, we want to get squared away the fact, have they paid you everything they owe you? Do they owe you vacation pay? Have they paid you your final paycheck? Did it clear the bank? Kind of an important question. Second of all, oh, believe me, that happens, especially with startups. You've got to watch that. Second of all, do they have some unpaid overtime that they owe you? Were you exempt or non-exempt? Were you eligible for overtime? Very often people don't know that they're not exempt. They think because they're, quote, salaried, that there's no overtime obligation, and that's wrong. As I said last week, I've got a client right now that was making $90,000 a year, but she's eligible for overtime, and she was working her tail off for this particular hospitality company, and she had weeks where she worked 60, 70, even 80 hours in a week, and we have presented them with a bill for a heck of a lot of overtime, and company was not happy, believe me. Now, other things you've got to look at. Did you get your meal periods? You're entitled to a meal period after between 4 and 6 hours of work. You're entitled to go to lunch or dinner, as the case may be, and it's a half hour. It's not paid, but you are entitled to take the time. If they choose not to give you that period of time, the company owes you a penalty of an hour of overtime. You're also entitled to take breaks, and these are paid. These are 10 minutes, and these are not working breaks. These are breaks where you're entitled to get up and stretch, go to the cafeteria, get a cup of coffee. Once again, there's a penalty if you don't get your breaks. So these are the kinds of questions that we ask. Now, the termination itself, was it just? Was it fair? Was it discriminatory? Do you think if you were a member of a protected classification, who are the protected classifications? People over 40, age, people in minority races, which would be Hispanics, blacks, even Anglos can be discriminated against if someone has a policy that discriminates against Anglos. Was it retaliatory? Did you complain about the fact that you weren't getting overtime when you should have? And rather than pay you the overtime, management just decided to fire you, to shut you up. Best way to get rid of a squeaky wheel, if you don't want to grease it, is to take it off the car. That works out pretty well. You can't hear somebody that's not there. So, and I've had that case. I've handled just about, in my 40 plus years, I've handled a wide variety of things. I've been involved with most of the major Silicon Valley companies. I've been involved with airlines and hotels and restaurants, newspapers. It's been a lot of fun, and the stories are legion, and we can't use names, but it's been fun. Speaking.
Dennis, I have a question about those bigger corporations. Say somebody gets into a situation that's just kind of a lower level entry position, and say you work at a company, Apple for lack of another choice. What would you do? I mean, this is Apple. Why? How do you get over the fear of even trying to tackle something like that?
Well, we will use, instead of Apple, we'll use the employer of everyone that calls into this show. And that is the Acme Corporation. But let's say this is the Acme Computer Company, which is one of the largest computer companies in the world.
Gotcha.
And you wonder how you deal with it. Well, you deal with it when it comes up. I think we had an email I saw coming in where someone emailed us that they had gotten a warning notice that they worked for a large employer, and that they had gotten a warning notice that was factually wrong. It was saying that certain things had happened when they hadn't. And they asked the question that they were asking me, and I get this a lot too, is what do I do about it? Well, the first thing you don't do is just sit on it and just make believe it didn't happen, because it did happen. Common mistakes that are made, some people refuse to sign them. That doesn't work either. If you don't agree with it, you sign it and say, I acknowledged I receive it. I don't agree with it. That covers you. But not signing it doesn't do anything for you, and you look like an idiot when you go to court if you ever get there. What you should do is, whoever wrote it, start at the bottom. If your supervisor wrote it, go to your supervisor and say, excuse me, you say here that I was late 3 days last week. I wasn't. Check my time cards. And then produce your time cards. And the person that wrote the warning notice is the best person to get it fixed with.
Sure.
But you start at the lowest possible level, and then you take it up through the chain. And what you have to do is, if you disagree with it, if it reaches some conclusions that you disagree with, you've got to document that. You've got to raise your issues, preferably in writing, because if you don't protest, if you don't say, I disagree with this and state the reasons why, if you ever go to court on something like this, you're going to be stuck with only their version of what happened. And you don't want that to happen, believe me. Now, a lot of people are hesitant to do this because they're afraid it's going to make it worse. The problem is that if you don't, the hole that you're in is only going to get deeper. I've got a client right now that got a 4-page warning notice and wrote a 20-page response.
Oh, no.
Yes. It was amazing. Now, she had some help. What she did when her employer started to say things that were erroneous about her, she came to me and said, what do I do about it? And I suggested that she talk to her supervisor who'd written it. That didn't work. So we then had to reply in writing, so that we responded paragraph by paragraph to what had been said. And if we ever get to court on that case, and I hope we don't, but we might, we're in good shape because we have protested at the proper time. And that's what you want to do. You want to be timely, because the object of the exercise is to keep your job in this day and age. Now, unfortunately and realistically, if somebody at the company, has got it in for you, and it's not discriminatory. I mean, personality clashes happen, and those are the ones where you want to figure out a way to get out of this situation as soon as possible, because what you don't want to be is, to use a term of art in the human resources field, you don't want to be managed out of the company. That's not fun, and it's not fun for you, it's not fun for the company. So that's one of the things that I do with people, especially executives. If you're an executive and you get yourself a warning letter, things are not looking good. Company management does not write warning notices to executives unless they have plans for them that are not being included in the next company executive picture. It's time to get the hint, and that's when you want to. That's where I spend a lot of time dealing with companies and executives who are not a fit any longer for whatever reason. But one of the things that you've got to do if you're given one of these severance packages is we have to determine if your discharge was discriminatory or it was retaliatory, as I said earlier. And how can you tell? Well, you can tell because were you treated differently than somebody else? And do you think that your membership in a protected class had something to do with that? And, discrimination is not as blatant as it used to be, but you can normally, people who are the victims of discrimination can normally get a feel for what's going on. They know what's happening. We welcome your questions, as we say. We'll be breaking soon, but after the break, give us a call now so you can get in the queue. It's 661-298-5487. That's 661-298-KHTS. Give us a call on the legal line with Dennis Kennelly and our guest, Nikki London, guest producer, Nikki London, who asks good questions. How long do we have before the break? About 2 minutes? Okay, well, we get to Nikki. Nikki has a interesting incident that she'll recite for you about what happens if you don't have a lawyer. And one of the things that you've got to realize, especially in California, as we say repeatedly on this show, this is the workers' paradise as far as workers' rights are concerned. There are more agencies enforcing more legal rights in California on behalf of employees than any other state in the United States. So, and we'll be, as the show goes on, I've been in contact with some of the agencies, and we're going to have agency representatives from the Department of Fair Employment and Housing, the State Labor Commissioner, the Division of Industrial Relations, which handles wage and hour claims, probably the Unemployment Insurance Department, also known as the EDD, the Employment Development Department, to let you know exactly what's going on with those agencies so that you know what to do in case you need their services, because a lot of people don't know where to go. And a good place to start is with a lawyer. So we about ready for break right now? Okay, we will be back on the other side.